Welcome, everyone. My name is Leslie Orloff, and I direct the National Immigrant Women's Advocacy Project at American University, Washington College of Law. We're very happy to have you here today to join us for this important webinar. I'm trying to figure out how to change it. As we get started, I'm going to first turn it over for a moment to Judge Reyes to tell you a little bit about, this is co-sponsored by NUAP and the National Judicial Network, and together with SIJS. Judge Reyes?
Hi, my name is Victor Reyes, and I'm the judge in residence for the National Council of Juvenile Family Court Judges. I would encourage you to look at the NJN as an incredible resource when we're dealing with immigration issues and trafficking in the state courts, and best practices to protect these very vulnerable people who at times need the system in order to establish the type of legal basis to be in our country, and who've actually struggled very hard to come to our country. And Leslie, can you tell us a little bit more about the NJN?
Sure. The National Judicial Network is a membership organization for state court judges and judicial officers, so commissioners, tribal judges, magistrates, judges, etc., decision makers, where 4 times a year we host peer-to-peer exchanges that are judge only, and 6 times a year we host webinars of topics that judicial members are choosing based on what's happening in their courts and the things they want to learn most. Together with membership comes technical assistance, our ability to create pretty much materials on anything you ask, and a really great way to connect with other judges in other states who are seeing immigrant crime victims, immigrant children, and trafficking victims, both immigrant and non-immigrant, in their courts, both adults and children. So if you're a judicial officer and you're interested in joining, there's a link at the end, or that will be put in the chat during the training where you can sign up. But we welcome you to join the National Judicial Network.
Right. And Leslie, just can I clarify one thing very quickly? Just as with the National Council of Juvenile and Family Court Judges, just because the word judges or judicial is contained within the title, the membership is not limited to just judicial officers.
It is actually. Yours, the NJN is, but NCJFCJ is not.
But then you also had the other organization, NAWA, is that correct?
NUAP, right.
NUAP, and then that one is not limited, is that correct?
Correct.
And so we encourage people to join that organization.
Great, right, and we have a listserv that you can sign up for. If you're interested, you can mention it in the chat, and Daniela, who's staffing us here, will get you signed up. As we get started, I want to thank the State Justice Institute for supporting this event. The opinions and comments that you'll hear today are mine, Judge Reyes, and Professor Thronson, and we're thanking you for joining us all. And don't forget, there'll be an evaluation that we'd like you to fill out at the end, and this link will be available in the chat and at the end as well. So as I said, my name is Leslie Orloff. I direct NUAP, and I'm very happy that you're here today. I'll let David, you want to introduce yourself?
Sure, my name's David Thronson. I teach at Michigan State University College of Law, where I work in our clinic and have been doing SIJ work since, I think, 1995 in various ways.
And my name is Victor Reyes. I'm currently the judge in residence for the National Council of Juvenile and Family Court Judges. Prior to being the judge in residence, I spent 15 years on the district court bench in the 10th Judicial District in Pueblo, Colorado. I had the opportunity a few times on the bench to address this issue, although I wish I would have known the information that I know now to have been able to do a better job. So we'd like to know, we created a poll, I believe, and who is joining us today? So I know people have already put some hellos in the chats. However, if
Annette, do we have a poll, or should people just mention in the chat? think it's, we don't, oh, there's the poll.
No.
Great.
So if you can go ahead, just let us know so we have an idea of the background. And it's just really exciting to see the amount of participants today.
Great. And if those of you that are other could say what other is, that would be great. Okay, so we're seeing about 7% judges and about 6% court staff and law clerks, 10% lawyers, family lawyers, 40% immigration lawyers, and 40% everything else. So welcome, everyone. Back to you, Judge Reyes.
Move that slide forward.
Okay.
So if there are questions, please put them in the chat. Throughout the presentation, we'll attempt to address most questions, and I will provide written responses once we're done with the webinar to any unanswered questions. So I think there are a couple features. One is the question, the chat feature, and I believe the question and answer feature.
Right.
Leslie, would you like them to put in both and we can save the both?
I think what I'd like to keep it in the chat. It's easier to track while we're talking. So if you could just use the chat feature for that, that would be great.
All right, fantastic.
So
when we look at the learning objectives of the webinar, at the conclusion of our discussion, you'll be better able to identify the children who are eligible for the Special Immigrant Juvenile Status, protections in the family and juvenile court cases. Also issue the findings of fact and conclusions of law that eligible children must obtain from a state court to be eligible to file. There have been new changes in the law. We'll be discussing a case out of California that will talk about the importance of what the judicial officers need to be doing. And then also, once again, understand how up-to-date laws, policies, and regulations impact the state court's role in protecting vulnerable children.
great, thank you. And so as we get started, very excited about this presentation today because it's the first one we've all done that fully, well, David's done a few before, but first one I've done and Judge Reyes has done that integrates fully the brand new 2022 regulations and 2022 policy manual from USCIS, focusing particularly on how those intersect and impact with state courts and what the family court orders need to be saying in cases involving special immigrant juvenile status. So I'm going to turn it over to David to get started.
So one of the things that our new regulations did was convince us that for most issues, we've been right all along. The regulations confirm a lot of things. Maybe in a few places they cut back or extend a little bit beyond what we were able to advocate for in the past, but we don't see big contradictions. But now we see new and more secure sources to cite as we're thinking about what happens. But our underlying statute has not changed. It's changed over time since first enacted in 1990, but we've had relative stability with this statute since 2008. And so our three primary things that we need to establish in family court to be able to move forward with a petition with USCIS is that the child is dependent on the court. That can be placed in formal state agency care, or that can be placed under the custody of an individual or other agency. We'll go into detail on that. Reunification with one or both parents is not viable due to abuse, neglect, abandonment, or a similar basis under state law, which is an important piece of it that we shouldn't lose track of, and that a child's best interest would not be served on being returned. This is the only place in immigration law where the best interest of a child is expressly given weight. And so as we think about these issues and how it breaks down, some of the things that the regs help us clarify are things like who's a child. Generally for immigration, a child is someone under age 21 who is unmarried. We have some clarification around what happens with age out issues. What happens if a child grows up and gets married in the process? Where does that go? They need to be physically present in the US throughout this process. We need to be legitimately in family court for a family law, juvenile law function and to be there. And we'll talk more as we break out of what that means. And then we'll talk about what this kind of lingering notion of DHS consent is, and when does the Department of DHS need to consent, and what will be the criteria for them to consent. So.
Oops. Judge Reyes, you're on mute.
Thank you. Leslie, how do these new regs and policy manual define the juvenile court and judicial determination that juvenile and family court judges must make in order for the SJIS eligible children? What do judges need to know with the regs?
So to start with, a juvenile court this is the definition: a court located in the United States as jurisdiction to make judicial determinations about dependency and or custody or care. So basically, any court, as David was talking about, family court or juvenile court, that can place a child or award somebody custody would be sufficient. And there's a variety of different ways that can play out. The other thing that I think is really important, though, is there's new language in the regulations that we're all going to kind of need to get used to. And they talk about, we're used to talking about state court findings, but they're now talking about judicial determinations, which essentially basically means that and this is what judges have been doing all along, but it makes it clearer. And I think Judge Reyes in our prep for this highlighted the fact that it's much closer to what judges are normally doing. You make findings of fact, and then you state your conclusions of law in your orders. And what the regs are saying is that those together are a judicial determination. There's findings of fact, so you need those detailed findings, but the conclusions of law are the statements about best interest, where you're going to place the child, reunification, etc. And so we're going to be using terminology today that talks about state court orders, SIJS orders, judicial determinations, because that by making those kinds of determinations, DHS has been instructed to not look behind the court orders, that they will defer to courts, because in that structure, findings of fact, conclusions of law, that judges always do, that signals to DHS that the court, that they can rely on this court's order, and they should and shouldn't be looking behind it. Judge Reyes, in light of this definitions I'm talking about, what are the best practices for state court judges who are issuing SIJS orders?
Well, this is an area that I think right now, with all the changes, that we need judicial leadership, because my experience with orders that are prepared at the conclusion of a trial or of a hearing is that usually either the lawyers for the child or maybe lawyers from parents, or maybe the county attorney, whoever is the state representative in your jurisdiction, prepares the order for the court. And I think that what we really need to start looking at is we use a lot of form orders that just say, based upon the facts, the court finds that the child is dependent neglected, and here's what we need to do. And we need to be a lot more detailed as to the findings of fact. Just like any appellate court judge who shows up at trial court judges trainings and says you need to start making more of a record. So we start with detailed findings of fact in the court order. I mean, Leslie or David, I guess I can throw this out. I can't imagine that lawyers are going to be getting transcripts of the hearing. They're going to be relying on the court's order. So we need to then not only make the detailed findings of fact, but based upon those findings of fact, we ought, here are our conclusions of law. And if we just break it down that way, it not only helps with the appellate record that is being made, but also what helps is for the subsequent immigration proceedings. So the USCIS is going to defer to the court on the matters of state law. So they're not going to be re-examining your orders to see whether or not you've complied. And as was indicated before, they're not going to be making independent determinations. However, when we start looking at the regs and what is needed, that's why it's so important that I'm going to say your record, number one also is the child is going to be protected. So that's why it's so important to make those very detailed findings of fact.
Judge, if I could just jump in there, since we have a question in the chat or a comment about USCIS pushing for transcripts and other things that pull beyond the order. And there's a tension here in advocacy, because on one hand, you want to give USCIS as little as possible, and you want to control it as an advocate and what you're sending them in a controlled form. The more your order sets out a factual basis and explains how it got to the legal conclusion that a child was abused, neglect, the reunification is not viable, because the less cause USCIS has to be looking behind that and say, well, we need more. We need to know this. We need to see the petition that went in. We need to see this. So I think over time, I do think it's worth pushing back on USCIS when they're asking for things and pushing to get more and more items, that are raw data in the record, because they shouldn't be looking behind the judge. But the better way to insulate ourselves a little bit is to make sure that order is not completely conclusory and check a box.
And in fact, with the new regs and the new policy manual, the more, if people follow what Judge Reyes is talking about, and that you have the detailed findings, and then you have your conclusions of law, so it's clear from the order itself that the judge had the facts and is making these conclusions based on the facts, then you are minimizing significantly the extent to which USCIS can and should be and will be, because they're going to be trained that they're not supposed to look beyond. So the thinner, more checklisty the order, the more likely they might be able to get around and look beyond. The more detailed the order, the less likely they will be able to. That's the way to think about it. So that's for both judges writing orders, but also the lawyers in the audience that are preparing orders. You're not going to scare, Judge Reyes, are you going to scare away, you're on mute, a family court judge if you have detailed findings of facts and conclusions of law?
No, I mean, family court judges have a ton of cases to work on. And the more the lawyers prepare, you always ask at the end of the hearing to prepare the order. One of the things that you may want to watch is there are judges who may make the transcript the order. So I don't know if people have had that situation that, I'm going to make my findings of fact, conclusions of law, and we're going to have the transcript printed out, and that's going to serve as my order. So once again, Dave, we're getting that situation you were talking about is how much the judge is putting in there with the findings that you may not want immigration to be cognizant of. Right. So there's no way I think judges are going to say, you know what, this order is way too detailed. It's just because, once again, the argument to the judges is to make the best record possible for appeal. So, and you're not doing it, you're not going to tell the judge, I'm doing this for immigration. Right. I would not imagine. And judges, are always trying to protect their record. So you're actually aiding judges, in my mind, when you're doing that.
And that's what I'm hearing from judges around the country as we do trainings as well. Few points to make that I just want to highlight is that basically you also want to make them clear in your orders, in the state court orders, that they're using state laws to make custody and placement decisions and memorializing it in the order. And that these cases, these orders reflect the judge's expertise in child welfare, in best interest of the child, in making custody and placement determinations, and in the application of state law. And that these orders do not provide immigration status. And that the order is one, for those of you that this might be newer to, this is one piece of required evidence in the immigration process, but not the sole piece. Oops, hold on, I skipped one. And that, you know, and the other thing is that the same procedural rules apply in family court as they do in any kind, in the regular family court case, the custody case, the divorce case, the delinquency, the dependency case, whatever case you end up in, it's those rules. And we have a tool, maybe Daniela can put it in the chat while we're talking. We have a tool that you can look up by case type, by proceeding type, what the service of process and jurisdictional rules are in your state or in the neighboring state in each of these types of proceedings. Oops. So David, can you describe the 3 most common circumstances where a child may be eligible for SIJS?
Well, so the mainstream ways that we see this, the last one on this slide is actually where SIJ got its roots and started. A child who was in the state welfare system. A child had been removed from parents and was placed in a foster care system of some sort. At that point, the child is not able to reunify with parents, and there is a state law reason for that that's been adjudicated. We can also see that this happens with children who are in guardianships. That's the second place historically we went with this, to say, well, you know, why would a child have to be placed in state care if we've removed the child, or if the parents are unavailable for the child to care for the child? Let's put this child in a less restrictive environment with a guardian or with someone else, a family member, a family friend, a responsible adult who can care for the child in that case. And then we also have children now, many children, the bulk of applicants for SIJ are children who are arriving at the border, taken into custody often by the Border Patrol, placed with HHS, transferred and placed with the Office of Refugee Resettlement in the Unaccompanied Children's Program, and placed in a system somewhere within the state. All of these children, if they meet those 3 statutory criteria, are absolutely eligible for Special Immigrant Juvenile Status. They might come before the court in lots of different proceedings. Now, the thing to keep in mind is these will have different names under your state law. They will have different practices as to what needs to be shown, what's the underlying criteria. What you don't see on this list is a proceeding to make Special Immigrant Juvenile determinations. You need a state law reason to be there, a legitimate state law reason. Now, it may be that one of, as we'll see, the primary reasons you're going to court is to think about immigration. That's an important piece of a child's well-being. But what's your state law purpose for being there? Is it dependency? Could it be delinquency, right? The child is coming before the court based on some action that they've undertaken and charges that have been leveled against the child, but that judge is making a decision about where the child's going to sleep tonight. In that instance, the judge is making a care and custody determination. We can look at SIJ. Could be protection order cases, who can and can't care for a child who needs to be protected, custody cases, divorce, guardianship. Take out your playbook of family law, of juvenile law in your state, whatever these are called. Look at them and say, you know, where can I go with this? Leslie mentioned the bench book quick reference guides on new website. You're going to have to do your own research once you get there and make sure everything's current in there, but a great starting point to explode you into lots of different places that you could look in state law in your jurisdiction to work with there.
So Leslie, I'm wondering, can judges make SJIS findings as part of temporary orders, or are they only limited to the final hearings?
Oh, that's a really good question. So David was mentioning, like, you think about protection orders, those last for a year, 2 years, 3 years, depending on the state. Yes, they can make SIJS findings as part of your temporary orders. There's going to need to be some findings of fact and the conclusions of law, the same things we're talking about. And it could be in a divorce, let's say a highly contested divorce case or a custody case or welfare proceeding, a child welfare, and they can. And what will happen is when the court issues the SIJ as a temporary order, by the time the case is adjudicated, USCIS is going to wonder, was there a final order? And they're going to want to see whether the final order is consistent with the temporary order. Did, they end up granting child custody to the batterer? Did they end up not finding the person has been abused? But if it's consistent with the order, then you want to, what the best practice for judges to know and for lawyers to know is, as soon as the final order is reached, if the SIJS case hasn't been adjudicated, submit it immediately. Do not wait for, the lawyers should not wait for a request for further evidence, because you want the full evidence to be in that case file when the adjudicator touches it for adjudication, if at all possible. So that's
can I ask a follow-up to both of you? So the child, the caseworker goes out and then seizes the child because of neglect or abuse in the home. And we're coming up for that 48-hour hearing, the first hearing that we usually have in juvenile court. And usually the court's relying on the caseworker's report to make findings as to whether or not the child is, a case should be filed.
Mm-hmm.
Is it at that point when we're talking about an order like that could start that process of basing the findings of fact on what the caseworker has observed to allow the filing? Does that start that first part of that process?
David, I'm going to let you answer.
I'm sorry, Judge, I'm going to have to ask you to repeat that a little bit. I was thinking ahead.
Yeah, the caseworker comes in, finds a situation in a home, and then takes custody of the child for abuse or neglect. You come up for that hearing within 48 hours to make a determination as to whether or not the state has temporary custody of the child. The court comes into court to start making a determination whether or not a case can be filed at the initiation. Should the judge then start it from that point to start making that record that we're talking about?
I think you start making the record. Now, if you're going to have another hearing immediately carrying on, that's going to be a disposition hearing at some point beyond this initial one. And that's going to come relatively soon, a disposition hearing, as opposed to, or an adjudication that precedes the disposition. Depending on how long in your jurisdiction there is a gap between these things, how they spread out, I don't think that we need to think, if we've got 48 hours to burn or something like that, that we're in such a big rush if we have another hearing that's coming right up, because we are going to get a richer order as the proceedings unfold beyond that initial set. But if there is a long delay, and you have enough evidence before you in the court, I think move ahead with these orders and then supplement them and issue new orders that go further as the case unfolds. But certainly you don't have to wait until a final disposition of the case to get the process moving.
Thank you.
So David, in what types of proceedings might an immigrant child in federal custody come before the court to obtain SIJS orders?
Yeah, well, again, very jurisdiction specific as to what that's going to look like. But by and large, we will have
you control.
I'll let you move it, Leslie.
Okay.
So, if we think about children in HHS custody, they likely will start off in short-term foster care, short-term custody, transitional foster care. While we're looking for appropriate placements, are there parents they should be reunified with? Are there other caregivers? At that point, the state system is not going to be involved in most instances, and we're not going to be before the court until that child is settled. But then the child, if we fail to find, if HHS fails to find a placement with a guardian who's appropriate, or with a parent or other relative, the child's going to end up in long-term foster care in the federal system and be placed. Now, this may be within the same agency. Here in Michigan, the same agency runs both a large short-term transitional foster care program and a long-term foster care program. But the child, at some point, when the decision is made that it's not viable to find a placement, they're transferred to the long-term program. And at that point, they're placed and they're brought before the court to say, this child's going to be here. We're going to bring this child under the court's jurisdiction. And at that point, for us, that's a dependency hearing to come forward. In Michigan, others will have another way in which the child is brought before the court to ratify that placement and say that that's a placement, and that the court will then monitor this placement as they do other placements and going forward. So whatever that provision is that's going through, and again, under state law, saying the court is assuming jurisdiction over this, that's the case that we're going to take that forward. So that formally recognizes the placement. And in those cases, HHS is asking the court to ratify the placement choice they have made. We're not contesting it. We're not telling HHS, you made the wrong choice, take the child out of this placement, put them somewhere else. So we don't need any express consent from them, because this is something that they have agreed and brought before us.
Oops.
So, you know, what are we going to look for in these cases? We're going to ask the state court, as they're making these findings, to think about, well, I'm going to actually back up a slide, Leslie. So this custody determination, right, that we're going to make, we, again, as the judges have talked about, we want some detailed findings of fact. We want a declaration. We want a finding of a conclusion of law under what the state law is that's going to take this forward. We've got a placement in the United States. We've seen all these different types of placements. And, you know, what does this look like? One of the ways we find that, you know, it's in the best interest for a child to be in the United States is that we look at alternative placements. We look and say, you know, are there parents back in a home country who are appropriate placements, who are clamoring and saying, please send our child back. We want our child home. In that case, we've got a determination of the sort that family court judges, juvenile court judges make quite often. Where is the best place for this child to go? But by identifying the possibilities, checking them off and saying, you know, no, the best custodian for this child, the best caretaker for this child, caregiver for this child is here in the US, and they support that finding as you would in any domestic placement. You have implicitly made then a best interest determination. The court is not going to place a child with one caregiver if there are better caregivers out there under the law that they would appropriately under the law come and look at. Again, reunification is not viable. That may not be the wording. It's almost definitely not the wording that you're going to see in your state statute, but it's implicit in that decision to put the child somewhere else. The primacy of parental rights is such that if it were appropriate to reunify the child with a parent, the court would do so. But the fact that they're finding under state law that there's somewhere else this child needs to be, that it could be mistreatment based on a parent, it could be inability of the parents to care for the child. As we lay that out, the default then is that reunification with the parent is not viable. Abuse, neglect, abandonment, these are terms which are going to have varying but somewhat comparable use across different state jurisdictions. You're going to use the language that you have in your jurisdiction as you're going to think this through. But don't forget similar basis. And I know people have trouble with similar basis cases at USCIS. These are difficult cases sometimes to make, but your judge can help you here. And you can think, this was a language that was added back in the day. The original Special Immigrant Juvenile Statute didn't say anything about due to abuse, neglect, or abandonment. It had other language. It said eligible for long-term foster care, which has now been replaced by reunification with a parent is not viable. But it didn't have that qualifying language, and that was added. And then it immediately became clear that that was a little too restrictive, that there were other bases that were legitimate state law, child welfare oriented reasons to take a child into care or to make a decision about the child's care that didn't necessarily fit strictly under abuse, neglect, or abandonment. I always think in New York, where I practiced back in the day, children were taken into care as a destitute minor. There wasn't any parent charged in that case with neglect in that instance. Here was a kid who needed care. And I always think the framing of this to think about, and it should be a generous framing. We're in state court appropriately for a state court reason, which is about the welfare of this child, about the care of this child. And as we do this, is the thing that we're invoking as a similar basis something that is motivated by similar ideas? It's motivated by caring for a child. It's motivated by state law rationales and judgments about when does a child need to be before the court? When does a court need to step in and make a decision about the care of a child? So, we get some special cases here on this, death of a parent. This is a question of state law. How does the state law treat the death of a parent? Now, I think, the key for me in arguing these cases in different jurisdictions is always thinking about it from the child's perspective, not from the parent's perspective, right? We're not so concerned about thinking, did the parent abandon the child by by dying? In that case, inconveniently dying and neglecting the child, or from the child's perspective, is there a need for care for this child who no longer, due to the death, has a caregiver? Our law here in Michigan, the child is present in the state without proper care, custody, or guardianship. That applies to a kid who's orphaned, right? That applies to a kid whose parent has died, that we go in and say that is similar. It's a state law reason. It's a basis under state law for bringing this child in.
Dave, I have a question.
Yeah.
As it relates, because we're mentioning state a lot, but am I also correct that what we're talking about applies to the territories? Puerto Rico, Guam, Samoa, because I know a lot of folks come through Puerto Rico from the Dominican Republic and from Haiti. So I just want to, we use the word state a lot, but we're talking about any court in any territory too. Is that correct?
That would be correct. District of Columbia, of course, right? Yes. So,
Puerto Rico, the Mariana side of the CNMI, all of them.
Right. Thank you.
Yep, that would be right.
So, and you'll see the California decision we're going to be talking about later has another similar basis spelled out that was in the prior slide. But what's also important to understand is that when judges, we get a lot of questions sometimes from judges about, well, for how long? It's not expected non-viability of reunification for how long? For, the kid's 2, are we talking about the next 18 years? Or if somebody's older, are we talking about a shorter period of time? Well, the regulations have defined that. Viability, when we're talking about non-viability, we're talking about, they look at points in time. They look at when the order was issued. They look at when the child filed for SIJS, which will be after the order was issued. They may have they may have aged out of the state's jurisdiction by the time they file, but they're under 21. And we're also going to be looking at when the application is adjudicated. And there's a 180-day time frame that could, with a request for further evidence, go a bit longer, but we're talking about well under a year is the time frame that we're talking about kind of predicting in that sense. Although it may be much longer, what the court would want. You'd need a change in circumstances under family law and all these other things. And that under the regs also confirm there's only 2 instances in which the SIJS order will automatically be revoked once it's approved if one of these 2 things happen before the child becomes a lawful permanent resident. And both of them require a court order. So if the court issues an order reuniting the child with the parent who perpetrated the maltreatment, that will automatically revoke a grant of SIJ. If the judge orders, let's say, that the best interest for the child to be placed in the child or their parent's home country, that too will revoke. But only those are the only 2 circumstances under which there'll be an automatic revocation.
So David, does the court, is it required to have continuing jurisdiction over the child until the application is adjudicated?
So generally, yes, right? That's our cleanest case is yes, that on the date that you file the petition, this doesn't necessarily mean that it needs to carry through until adjustment of status, but on the date you file it, through the adjudication of the underlying SIJ petition, the I-360, you would like the child to remain in care. You don't want a situation where while this is going on, a judge has turned around, as Leslie said, and place the child back with the parent, because then our underlying reason for getting this order is no longer in case. But we do have some specific jurisdictional carve-outs for this. If the child ages out, we're fine. As long as this child files before they turn 21, while it's pending, the child may age out, will leave care because of age. The child may be in a jurisdiction where care does not continue until age 21. If the child leaves care because of age, if they were filed at a time when they were in care and the care was still valid, still subject to this, the fact that they aged out is not a problem after that happens. And we also have adoption as a way that might end court oversight, because once you have adoptive parents in place, the court steps back and the parents are in the position to care for this child, and we don't want to delay an adoption, right? This is a good policy sense. We had a lot of trepidation about these cases earlier. The regs now make clear that an adoption is a continuation. It's in essence a perpetuation, a real finality to say we're not going to reunify you with your parent. We're letting somebody else adopt you, right? In this case, and we're moving forward, and that's the better placement. So those are fine. We also need to be careful when a child moves to another state, and I don't want to get too detailed into this now, but it depends how and why the child moves to a different state. Does the child remain under the care of the court in the sending jurisdiction? Does the court place the child in another state? Has the child run away to another state? Have the guardians unilaterally moved? What happens? This can be very fact specific as to what's going on. Do we need to bring the child under the jurisdiction of a court in the receiving state at some point to domesticate or ratify or renew a guardianship in that state? So there'll be some nuances based on the particular circumstances of how the child moved. But simply saying, oh, you're out of state doesn't automatically say that anything in particular has happened. But we should always, when you have that kind of case, take real care to sort it through and say, does this basis of jurisdiction over the court still have continuing viability, or is it somehow ended in this case, or should it be shifted or moved somehow?
And David, just one thing to jump in and say quickly is that the policy manual here basically makes it clear that if there's a gap, let's say you move from one state to another, it was something that another state's going to take jurisdiction and they're going to reissue the orders or whatever. If there's a slight gap in between, USCIS isn't going to have a problem with that. So they've clarified that much that I think is helpful. So David, or I guess, Victor, you're gonna take this.
Right. And well, just, and then you talked a little bit, David, about the age of a child and how that impacts the eligibility. How about marriage too?
So in a similar way that we're going to say that a child, if you filed and before you turned to the disqualifying age, that's fine. We're going to protect you from age out. You don't need to remain unmarried through adjustment of status any longer, but you do have to remain unmarried through adjudication of the I-360. So you need to be unmarried at the time. This is part of the Immigration and Nationality Act's definition of a child, under 21 and unmarried. It's written into our definition, so it's hard to get around in that sense. So at the time you file, you're under 21, you're unmarried. At the time of adjudication, you haven't been married yet when the I-360 is approved, but we now know that adjustment of status may come much later because we have children in particular who are in backlogs and many years might go by. We don't need to put that kid's life on hold at that point. So once the I-360 is adjudicated, as the child is waiting to become eligible to adjust status and moving forward, at that point, it's perfectly fine to get married and do something that in the past would have created major problems.
Right, but you're not going to also have, I would hope lawyers aren't going to have the parent okay the marriage if the child's under 18, right? I mean, that's going to defeat the purpose of even submitting the application.
Meaning having the parents who you're saying you can't be reunified with step in to make decisions about that. Well, if you have the child in a situation where there's care and custody has been removed from the parents and somehow placed with a guardian or with the state, then I would think that the parents would not be in a position to offer that permission and move that forward if your child. But keep in mind, this could be someone over 18, between the ages of 18 and 21, where it's happening, or it could even be older if you filed before 21 and this gets adjudicated within 180 days, we hope. But they're over 21 even at that time. So parental permission may not be a relevant thing at all, or any kind of permission, because the child may be legally an adult even while we're able to characterize them as a child or a juvenile for SIJ purposes. So is it okay if part of the motive for seeking an SIJ order or for seeking court involvement at all is for the child to gain immigration relief?
This is something we've gotten some good clarification on in the regulations themselves and in the policy manual, that an application is considered bona fide if a primary reason, one of the reasons they went to court is relief from abuse, neglect, abandonment. So even if you have a child who's 17 years, 10 months, and they're being raised by, because many of these cases, if you think about it, any child who's abused, abandoned, or neglected, or some other similar basis under state law, who comes before a state court, even where the abuse happened in the United States, could qualify for SIJ. So we've had cases where, sometimes particularly the permanency planning that you can do in a custody case by awarding custody to mom and making findings of dad's abuse can have a legitimate state court purpose. I mean, because you don't know what's going to happen to that parent in the next couple of months. We've actually had a case with an older kid where the mother was hit by a car 2 months before, or a month before the child turned 18. And dad, the abuser, tried to come in and do something. So there's lots of legitimate state court reasons, but you want to make sure that that mixed motives are okay, and that that the immigration can be legitimately one of the purposes.
Right, and then we look at this idea of helpful court orders. Once again, we're back to the idea of factual basis, and any court order related to children intrinsically involves the child's best interest. And that's what the court is supposed to be doing in preventing future harm. but we need to make sure that that wording is contained within the orders themselves. So once again, it's making sure that the orders are clarified and able to just be relied on instead of anything else.
And just to address an issue someone raised in the chat, that could be true even if the child is on the verge of turning 18 or on the verge of becoming an adult, where it does look, and you have a more uphill battle to say, hey, I'm not here just to get immigration findings because I'm going to turn 18 next week and be an adult. What's my state law benefit? But, we can always go back and say, that state law has a cutoff date for a reason. And it says a child under 18 under state law has a right to be here. And what is it you can get out of this? Is it establishing a formal relationship? Is there something that needs to be done? Is it something that's more lasting to, if it's a termination of parental rights type situation or case, that would extend well beyond the 18th birthday. So you have to work harder in those cases, I think, to be able to articulate your state law reason for being there. But it's there. Otherwise, state law wouldn't let you be there in the first place, right? You just need to, you're gonna really have to work at it and figure out how do you come up with that.
Okay, so as we have about 9 minutes or 8 minutes left, I'm gonna turn now, I'm not gonna go into the details of the facts, but you have them on the slide. I want to highlight some of the findings of the California Supreme Court in their recent finding in the in re guardianship of Saul H. Short way of talking about it is this is a case where the court ignored the evidence from the child, relied on supposition about what, and applied the Nicholson case essentially from New York, standards that don't apply in these types of proceedings. And this in a decision in which all justices have concurred in the US Supreme Court, they are giving very clear direction that I think are helpful, not only in California, but to judges everywhere issuing SIJ orders. And basically what the Supreme Court said is they should issue SIJ orders, courts should issue SIJ orders anytime there's evidence to support them. They should allow a child to obtain a relief from parental abuse or neglect when one of the reasons, and they actually quoted the new regulations, a primary reason for it, and mixed reasons are okay, that the child can benefit under state law. They provided a helpful interpretation of not viable, and they talk about thinking about it as workable or practical to force the child to return to live with the parent who harmed them. And that they say states must apply state law in deciding whether or not return to the child's home country is in the best interest, and not be looking at the laws or what they think the laws might be in that home country. Courts must not base their findings on whether the child's parent is blameworthy. It's not about that. It's about the child's needs and the child's welfare. When your state law best interest says child's wishes are supposed to be considered, they must be considered. Courts shouldn't deny that. They shouldn't as I said earlier, disregard the evidence in the record and look instead at their own surmise about what might be happening, or look at extra record evidence, and really apply state law definitions to facts wherever they occurred in the world. And remember that the state courts are not making determinations under US immigration laws, they're making state law determinations. And finally, they have recommendations for courts is, consider whether the facts are established, even if the only evidence is the child's declaration. The courts can, examine and cross-examine the child like they do in any other kind of judicial proceeding. If you're going to deny, if the state court is going to deny the SIJS findings, they need to state its reasons. And again, this is, I think I've summarized most of this, but you have more of it here available for you. And we also have a tool that we can share with you, that we share with you in the materials. David?
So, the case law, and Leslie just went through a great decision that a lot of people advocated hard for out in California and nationally to push that through. Just a note, we've now got regs finally, after decades of not updated regs and case law that developed in some instances without these or under language that predates what we currently have in the statute or not. So just thinking about old case law, a lot of it's still good law and still good for us to advocate, but it might say things that, hark way back to pre-2008 statute where we're talking about long-term foster care instead of family reunification viability. It might be before we had our one or both parents language and a state law under an interpretation, or prior to the regs coming out and clarifying this, and the guidance clarifying this, making Nebraska making a decision to say that, we're not going to do a one parent case. So you always want to take your case law and think about, is it good, is it not? Don't throw it away because it's old and it's pre-reg, because some of that's going to be good for you in your jurisdiction to say, okay, the regs now come and ratify what we've said. They're making it easier, but I've still got this case. But also just be careful with your language as you're using it, and things to update. And there might be things, there's some really old case law on consent that sounds really screwy under our current understanding of what that means. So as you get there, be careful, but case law is still almost, by and large, really positive for SIJ applicants. There are some bad cases, but most of the case law is going to be your friend.
Okay, we've got about 2 or 3 minutes left.
Go
ahead.
Yeah, let's go right into the best practices to address these orders. Once again, findings of fact, the age of the child, the making sure that we've got the parents and we name them specifically. And in case that they're one of the parents is unknown, maybe even the efforts were made in order to identify a parent. Also the details of the remedies, nothing generic. I guess that's the bottom line, and what we're talking about here is moving away from generic orders to providing specificity. And I think it works for the child's benefit, because then people have an idea of what the child needs in the future as far as treatment, as far as being, open for adoptions or permanent guardianships. So when we look at this, citing state orders, where do you want us to go from here, Leslie?
I'm skipping to the next slide with David because we're running out of time.
All right.
So just to keep in mind, right, that we've been talking about family court and that piece of it. So this is the setup to go to USCIS. It's not automatic that we get, the better we have our ducks lined up coming out of juvenile court, coming out of family court, probate court, the better we're going to be set up to walk this through USCIS without the infuriating RFEs that we get, where they ask for something that you submitted and you flagged and you highlighted and you put it in your cover letter, and then they turn around and ask for it. These are systemic questions and problems to think about. And, all I can say is just hit it hard and play and make your filing as clear as you can get. We still have a backlog for children coming out of the Northern Triangle countries, from Mexico. So we are now in a world where a child who has an application for SIJ status pending can get deferred action, will automatically be considered for deferred action, which gets them an employment card. And this is huge. It would be better if that visa were immediately available, if they could adjust status and we get them a green card. If we could get an employment card based on a pending adjustment, we'd be much happier. But getting them that employment card is huge for many kids, especially older kids, that chance to engage in different ways, to have that government issued ID. It's important in so many ways, and deferred action is a way that we can get there. as we're thinking.
And that's
You need to be-
important, actually, David. One thing, judges should know that this means work authorization and a state-issued ID, a driver's license, things like that. And in some places, the deferred action triggers more access to public benefits. And then, go ahead, David.
Yeah, I was just going to say, please don't travel until you get your all of this settled and moved away. You do need to be in the United States for the SIJ. And, also just think, if we have a child who's under the watch of a state court, that traveling even out of state or out of a jurisdiction, and certainly out of the country, is not just about immigration status. It's about continuing the viability of that order and the court's role. And so not something to be encouraged or looked at as
so I think what we're also saying is the cleaner the better. I mean, you don't want ICPC issues, you don't want any, and I think, isn't that the bottom line what we're talking about here, Leslie and David, is the fact that if we can just make this a really clean record,
Right.
and just keep this within, with an objective in sight, that it just benefits the children so much more than all of a sudden, allowing people to do things that just don't make sense.
Exactly. And so that's exactly right. Write clear orders. We have a tool available for you where you can look up, because as children file for SIJS, when they file, they become eligible for healthcare in many states. When they get deferred action, they get their driver's license, they get more benefits eligibility. You can look up on our state benefits map what an SIJS child before you in court is eligible for, so that you can make sure they get to the services and supports they're eligible for. And I'm going to start wrapping this up now. I know there have been any questions that we weren't able to get to in the chat. We will follow up in an email to you. There are materials on our website. Please join the network if you are a judge. Our next webinar that the network and NEWAP are sponsoring has to do with what attorneys and prosecutors need to know about VAWA confidentiality and discovery. So you can join us on October 14th for that. And you can contact us for technical assistance at this location, this information, go to our web library. And then for SIJ, on the page we're sending you, there are, you'll have the SIJS bench book, an annotated compilations of the regulations with full regulatory history, a case law chart with all the a summary of all the cases that David was talking about and others. There's a tool on the California case, jurisdiction and service of process charts, best interest charts, and state benefits charts to make these cases a lot easier for you and to help make sure that the kids that you're working with who are eligible for SIJS will be able to get everything they're legally entitled to. So thank you, everybody. Don't forget to fill out the evaluations. And I want to particularly thank NCJFCJ for sponsoring and hosting this, Judge Reyes for your participation, Professor Thonser for your participation, and for all the work to all of you that you do helping SIJS eligible children.
Thank you.
Annette, can you stop the recording? We stay on for a minute.
Lost the judge.
Oh, we lost the judge. Okay. Sorry, David, I was moving it forward a little bit because I realized we were running.
Oh, no. You're absolutely right. Absolutely right. So
but I think we covered everything and people seem to be happy.
We did. There's things in the chat saying great, but wish we had 2 hours, right? Which is better than them saying, oh God, this drug out, right? So yeah.
Right. So, no, that's good. So David.
Hi, Leslie. Oh, I'm
Hi.
sorry. I don't mean to interrupt you guys. We still do have participants slowly leaving the room.
Okay, that's fine.
Okay, just letting you know.
You can stop the recording though.
Okay, will do.